Palmer and McGowan both guilty.
After thousands of billable hours, hundreds of hours in court, tons of newsprint and terabytes of data on social media, a judge had just handed down a decision that Dennis Denuto could have seen coming.
What the is that?
By calling McGowan a liar about why he closed the border, Palmer did in fact defame WA's Premier. And by calling Palmer a threat to Australia, McGowan did in fact defame the billionaire.
From the outset, I need to be really clear that I am severely constrained in the answers I can give to your questions because there are still matters that are live and to be decided by the court.
And the whole thing was a colossal waste of the court's time.
The game has not been worth the candle.
I want to vote for the judge.
You could tell this guy couldn't believe he was having to rule on such an absurd case. As way of background, he went through the text messages that Attorney General John Quigley sent to Mark McGowan, which were made public during the process of discovery.
But the side wind could drop the big fat man on his big fat ass! ! Hey, are you glad me single again, not making love in sweet hours before the dawn, instead worrying about how to defeat Clive! ! Smiley emoji face, smiley emoji face, smiley emoji face, crooked smiley emoji face.
So cringy.
Nobody came out of this looking good, but Quiggers emerged looking particularly bad. Central to the defamation case was an ABC radio interview in which Quigley explained why he had to pass a law preventing Palmer from bankrupting WA by claiming $30 billion in damages because of a government decision years ago to deny him the right to build an iron ore mine in the Pilbara. In that interview, Quigley revealed the inspiration for the Iron Ore Processing Mineralogy Agreement Amendment Bill 2020 wasn't legal or political luminaries, it was Danny Green.
As I said to you, it's like a fight. And like my near neighbour Danny Green says, you've just got to jab, jab, jab with your right and move him over to the left and then just knock him down with a right, a left hook.
When Quiggers testified in the defamation trial, he said things that completely contradicted that ABC interview.
I don't know where I am.
And when asked to explain the inconsistency, he told the court to ignore what he said on radio because that was completely and utterly false.
That's embarrassing.
Yeah, what's more embarrassing is then having to admit that the thing you said, then said was totally false, was in fact totally correct.
Mr Quigley was placed in the uncomfortable position of having to concede that part of the account he gave in the radio interview was not, open quotes, completely and utterly false, close quotes, as he had asserted on 9 March 2022, but was, in fact, open quotes, completely and utterly true, close quotes.
The judge said Quigley's evidence was confused and confusing.
To similar effect, my comment at the time was that I considered Mr Quigley's evidence was not dishonest, but was all over the shop.
The haphazard testimony suggested that Quigley was
not a reliable historian of events.
One of the highest courts in the country has just ruled conclusively that WA's first law officer gets confused about matters of law.
Am I in trouble?
No, you're our boss.
Oh, right. Are you in trouble?
Quigley came out bruised, as did Palmer.
He was generally a combative and evasive witness who, on more than one occasion, was unwilling to make obvious concessions.
The judge was particularly scathing of Clive's assertion that he genuinely felt fearful for his life because Mark McGowan ran a one-party state and was above the law.
The unsettling spectre of Western Australian government thugs or assassins needing immunity from the state to absolve them from the criminal consequences of physical violence had, I confess, not occurred to me. To even his most rusted-on partisans, Mr McGowan would be unlikely to have been thought to resemble Ian Fleming's fictional MI6 character James Bond.
On that last point, Judge Michael Lee, you are clearly wrong. James Bond is military trained. Just like Mark McGowan.
Welcome aboard, it's love.
And if you can't see the similarities between moves like this and this, then you, sir, are not fit for the bench.
The judge described Palmer's evidence as fantastic.
But not in a good way.
He gave fantastic evidence in the original but now secondary sense of that word. This submission is fanciful.
And he was perplexed by Clive's argument that he wasn't a political combatant because at the time of the mudslinging, he wasn't running for office.
And that's my kind of party, the United Australia Party.
So that's Quigley and Palmer. What did he say about McGowan?
He said generally Mark McGowan was a reliable witness, but occasionally couldn't help himself from being a politician.
I didn't bring the action. I didn't bring the action in the courts, just so you all understand. I didn't do it. I responded to it.
The judge made the observation there were similarities between life in a courtroom
I want the truth! You can't handle the truth!
and life in a press conference.
Are you embarrassed about your personal text messages being exposed?
I've answered those questions.
So the judge ruled they defamed each other. What about damages?
The judge explained very clearly that when awarding damages, he had to take into account one critical thing.
There is an appropriate and rational relationship, close quotes, between the harm sustained and the damages awarded.
He explained that damages were awarded for three reasons: consolation, reparation to reputation, and vindication of reputation. And in assessing the damage caused to each reputation, he had to take into account the nature of political debate in this country, which could be vigorous and often sarcastic.
It was like being flogged with a warm lettuce. Flogged with a warm lettuce.
He ruled there was very little damage to Mark's reputation, as evidenced by both opinion polls.
That at the time of the first cross-claim matter in July 2020, the West Australians celebrated Mr McGowan as Mr 89%.
And election results.
This victory made the landslides of 1978 and 1981 look close-run things.
McGowan, Justice Lee said, was at the top of his game and nothing could hurt him. The judge said that Palmer's feelings may have been hurt, but the billionaire had misinterpreted what caused that distress. It wasn't McGowan's words that hurt Clive, it was the legislation.
It seems to me that his real frustration and anger, unsurprisingly, was directed to the passage of the Amendment Act.
Damages awarded to Clive Palmer after McGowan defamed him 6 times came to $5,000.
Wow.
Damages to McGowan after Clive defamed him 9 times, $20,000.
So a huge court case for a piddly result.
Exactly what the judge said.
Consumed considerable resources of the Commonwealth and, importantly, diverted court time from resolving controversies of real importance to persons who have a pressing need to litigate.
He said politicians in particular should be mindful of launching defamation action.
Political figures occupy a special place in our system of representative and responsible government.
And costs?
Find out 11th of August. The judge made it clear they could be substantial. That's bad news for Clive, who made only $700 million last year and now is down to his last $19 billion.
So who's going to pay the $5,000 to Palmer?
You and me, taxpayers. McGowan says he did what he had to do.
Due to the significant risk to the state, I took action to protect Western Australia, to protect West Australians.
But any time he was asked something a little tricky at the post-judgment press conference, he fell back to one line.
Look, I accept the judgment. I accept the judgment of the court. I accept the judgment of the court.
Proving once again that the judge nailed his decision.
What might be described as the muscle memory of a questioned politician in being non-responsive.
No winners here.
No, there are some very clear winners here. Lawyers. I'm Ben Harvey. For more update, click the subscribe button below.